72 of At Your Service with Haber and Martinez. I'm Haber. Martinez is off to my right, maybe your left, depending upon how the screen is viewed to you. And today's episode is entitled Frequently Asked Criminal Law Questions, a Lightning Round. Basically, what Ed and I are going to do today, as Ed pointed out when we discussed the show, is we're going to do exactly what we intended when we created this show. Go ahead and tell him, Ed.
We are going to tell you what the common everyday person who's not a lawyer, the most common questions that they have that Michael has come across. So these are questions that this is what the show was for. We did this to help people that are not lawyers, or the questions that you commonly ask that somebody now is going to answer for you that's actually practice law. So you can get those answers to those basic common questions that you have.
So I want to add a couple things to that. And I want to say that the show is premised. What we're going to do is we're going to take real world questions. I spend an awful lot of time fielding legal questions on a site called AVO, AVVO. It's an online legal community, and it's nationwide. So there's lawyers in every of the 50 states that subscribe and answer questions or provide responses to questions. So there's no confidentiality. It's not an attorney-client relationship. It's simply the functional equivalent of you hopping onto WebMD, and instead of a robot answering a question, you're typing in your response, and somebody is actually typing back a reply to you. In this case, it would be lawyers responding to legal questions. And they're in every area, every conceivable field of the law. Obviously, I stick to what I know. I stay in my lane and answer criminal law, criminal defense, criminal procedure, evidence, constitutional law, juvenile law, domestic violence, DUI, BUI, seal, expunge, things that Ed and I routinely handle, I field all day long. And, we've been told, I guess, there's no such thing as a stupid question. Well, that's not true. There are plenty of them. And there are plenty of people who ask questions in a stupid way. And by stupid, I'm not talking about intellectual capacity. I'm just talking about the more generalized concept of not well thought out. So we're gonna kind of go through them. Remember, these are all questions within the last week to 2 weeks that I have actually answered. Ed's not he's on Alvo, but he's not on it like I am, regularly fielding these questions. I've got well over 38,000 of them underneath my belt. So he has never seen these before. I'm going to read them to him, read them to you, and he will answer them as a first-time answerer, and then I'll chime in on whatever, I may have to add to it. So, you got to figure kind of when people type these questions and submit them, multiple lawyers see them. And I've always said that you could go into a room with 5 attorneys, ask one question, and get 5 different answers. Doesn't necessarily mean that one of us is right or 5 of us are wrong or what have you, because we all look at the world through different experience, different lenses, different filters, different prisms, and we have different approaches and different ways and different strengths and different weaknesses. Sometimes we're blind to one thing because we don't know it, or we may be more perceptive to it because it's in our common everyday realm. So things like second opinions are really valuable for stuff like that. I mean, imagine if you go to the doctor and the doctor says to you, listen, I'm really sorry to tell you this, but you have cancer and we ought to operate right away. Before you go into the OR, you may want to get a second opinion. But how would you get that second opinion? Would you just pick up the phone or hop onto WebMD and ask for it and be satisfied? In the legal arena, when you want a second opinion, you need to go to a real world lawyer with a copy of your file, with your discovery, with your police reports, with your body worn camera, with as much information as you have, so that the lawyer has a shot of giving you an honest assessment. That said, it's not always practical, and some questions are, or some issues are addressable or answerable online. So it's not always inappropriate to do. I don't want to discourage anyone from doing it, but I do want you to understand the natural limitations that it comes with. We don't know you. We don't know your case. We don't know your judge. We don't know your prosecutor. We don't know your history. We don't know your unique facts and circumstances. We don't know the things that separate you from the person sitting next to you who happens to have the same charge but shares no other experience with you. So all of these things are very case specific and unique. But with that said, let's go ahead and get started with our first one.
Get started. I'm scared to see how many I'm going to get right or wrong, but let's see.
Okay.
I'll do
So,
my best.
Very simple question. By the way, there's usually a question and then a proffer. This one has actually, the question and the proffer are the same. Am I required to warn someone if I feel the need to pepper spray them?
Okay. The short answer is no. You're not required. That, however, is not what I would say is the best answer. I think the best answer is to try always to de-escalate things so that there's no doubt that you're not the aggressor. The real question here when it comes to self-defense, and I'm assuming when they said, am I supposed to tell somebody when I pepper spray them? Let me again, see, this is what Mike was talking about. Facts are important. I am assuming that they felt that they were threatened. You can't just go up to random strangers and pepper spray them, okay? But assuming that you feel threatened and you're asking, can I pepper spray somebody in self-defense? Do I have to say it? No, but the better position is, yeah, try to always de-escalate. So if anybody's recording or anybody's watching, when the cops show up, they can say, well, they actually tried not to pepper spray this person and they warned them 2 or 3 times. You keep being aggressive. You keep charging me. I'm going to have to pepper spray you. It's a lot easier for Mike and I to then file a stand your ground motion. How'd I do?
You did great. That's exactly how I answered the question. I basically said the issue here is whether or not you are acting in self-defense or whether you're the aggressor. If you're pepper spraying somebody just because you feel like pepper spraying them, or because they're annoying, or because they won't shut up, or because they're sitting in the row in front of you or behind you in the movie theater and they're on the cell phone, no, you just can't turn around and pepper spray people for that. That's a criminal act.
Unfortunately, as of today, it is still not illegal to be an asshole. I mean,
right. It's also not illegal to carry pepper spray. I mean, irrespective of constitutional carry, it's not considered a weapon. Right. So the answer is, again, it's real simple. You have to go to the issue of the why of this. Why is this person asking the question? If they are asking hypothetically, look, if somebody attacks me, I know I'm carrying pepper spray as a defensive tool. And if somebody attacks me, do I have to tell them, hey, wait, before you come any closer, I've got pepper spray? No, as Ed answered, absolutely not. But the way that I answered this question was, I gave them links to 2 of my #HaberPA video FAQs. One, number 214, what is stand your ground? And basically that short video tells you, when are you allowed to use force? In defense of yourself, in defense of others, and in defense of property, where you feel that you're in danger, where you feel that it's necessary for you to defend yourself, and where it's also objectively necessary. And then I referred them to number 219, what is reasonable force under self-defense or stand your ground, because the force you use has to be reasonable. So if somebody looks at you and says, you're an asshole, can you pepper spray him in the face? No, I mean, you could do what you want, but it's probably not going to be considered reasonable under the circumstances.
I want to add one thing before we move on. And the reason I tell you that it's best to be vocal about warning them, okay? So in this case, it's a pepper spray, but let's say it's a firearm. If you pull a firearm on someone and you tell them out loud where other people can hear you say, listen, I can't fight with you. I'm scared of you. Don't come at me. I'm whatever. And you say, I have a gun. If you continue to charge me, I'm going to have to, not I will shoot you, right? It's better to say things like, I'm going to have to shoot you. I have no choice. It is actually easier for Michael and I to defend that on Stand Your Ground, even if the person that attacked you did not have a firearm. Because the issue then becomes, in your mind, you're thinking, if I tell this person I have a gun and they continue coming at me, they are definitely looking to do harm to me. At least a reasonable person would think that. And it's reasonable to believe that they're armed themselves with some type of weapon, because you'd have to be nuts to charge someone with a gun and you don't have something. So it's always best to try and de-escalate it. It makes it easier for us.
But don't take that as license to start firing warning shots.
No,
that's a whole different issue.
I never said fire a warning.
No. I'm just making sure people don't extrapolate that from what you said.
It's a good point. We didn't say firing a warning shot is not allowed. Letting them know you're going to shoot them if they continue coming at you, that is allowed.
Let's go on to our next question. Why would my PTI is diversion. Why would my PTI be denied for a first offense when I have no prior record? Now, here's the proffer. I am a bartender. I was issued a ticket during an undercover operation at my bar for serving alcohol to a minor. We have security at the front door who checks IDs. Once the person was inside and at the bar, I assumed that she was of legal age. So it seems to me I was basically set up. I went to my pretrial hearing. The judge offered me PTI. I have no record. I have no priors. I've never been in trouble, yet they denied my PTI.
Okay. Number one, the judge could not have offered you PTI. Now, I'm not saying he didn't or she. I'm not saying they didn't. It's very possible that they tried to offer you PTI, but that would be illegal because it is not something under the Florida statute that's done. That is something internal in the state attorney's office, which brings me to one of my favorite issues. Why didn't you get PTI? Well, because PTI is something that only the state attorney can offer, and they offer it for people that they believe should get it. So they, for whatever reason, it's at their discretion. Now, I don't know if you hired a lawyer. That might have been part of the issue because Michael and I will tell you, navigating for PTI is a very, very sensitive matter. We're not arguing the law. We are arguing concepts and opinions to the state attorney. We're trying to get the state attorney to understand that you're the type of human being that deserves PTI. So I can't argue the statute. I can't argue that they don't have the evidence. I got to be able to argue he's not a bad guy. Why not give him PTI? And that's a little dicey. That becomes now knowledge of the human condition and how you get along with others. And some lawyers are just not built for that type of negotiation. I know Michael is, because I remember when I was a state attorney, Michael was really good at trying to convince me that almost every single one of his clients deserved PTI. Didn't work often, but man, he was good at it.
Well, I think you raised the most important point is that a lot of times when you get these proffers, they're just not factually accurate. Sometimes people just don't understand the dynamics and they're stating what they believe, but other times they're just completely off the rails. I don't know what this particular asker's question was, but the first premise is absolutely wrong, as Ed pointed out. Judges cannot, do not, and will not offer PTI. PTI is a program that is exclusively owned and operated by the state, and they have 110% authority to admit you, to graduate you, or to bounce you out. It is entirely up to them, and there is nothing that a judge can say or do to make the state do one thing or the other. That said, why would you be ineligible for PTI? Well, it's pretty simple. I'm going to differ a little bit with what Ed said before, because I'm going to say that there is a statutory requirement for diversion, but the statute requires each independent state attorney's office. We have 20 different judicial circuits, so each of those offices creates their own protocols for PTI. And then once they create those protocols, they're bound to follow them. So those protocols, for example, here in Dade County, you can get diversion for a DUI, which we call back on track, but you are disqualified under certain conditions. If it's not your first DUI, you're automatically ineligible. If you have certain other aggressive driving history, you're automatically ineligible. If you blew over a .25, you're automatically ineligible. If you had a child in the car at the time of the DUI, you're automatically ineligible. So there are things that you can do to cause yourself to be ineligible. That said, once you are accepted, you can also get bounced out. Your behavior or your lack of behavior, your ability or your actual doing what you're supposed to do, when and how you're supposed to do it, or more importantly, not doing anything you're not supposed to do, can get you bounced out. So it may be that this person was ineligible. It may be that they failed to do something, or that they did something they weren't supposed to do, or it could be for any other reason. But at the end of the day, the person asked this question of is not random lawyers on the internet who know nothing about you or your case.
That is true.
It's the only person who can put you back in the program or get you in the program, and that is the state attorney. It could be something as simple as this, because I've had people who were qualified and referred by the state attorney to diversion. And when they went to register, they were not accepted because diversion found priors in their history. Turns out it wasn't them. Somebody with the same name, possibly even the same name and date of birth, which happens here in Dade County, believe it or not. So sometimes you need to go through the why of these things. You have to figure out, why wasn't I admitted, or why was I bounced out? And then get a lawyer to help you to negotiate to get back in if that's what you want.
Michael, and in fairness, he said he had no priors. So that's one of the main reasons you would not be eligible. is if you have priors. But again, everything Michael said is factually true. However, everything I said is true because there are exceptions to the rule, right? So even
Right,
if
and he may not know that he has priors,
right, but I'm saying
because it may be, for example, you could have a DWLS case that you pay the ticket on, and you wind up with a criminal conviction that you never knew you were doing.
right.
So again, anything's possible here.
And for example, there are exceptions to these reasons that you would be ineligible, right? That you're ineligible if you have a previous DUI, you're ineligible if you have a previous felony. But there are exceptions to the rule, right? If there's a problem with the case or there's a million. I could be here for hours with different reasons that a state attorney, you might be able to convince them to give you PTI, even though technically you were ineligible. For example, what if he was arrested 3 times for selling alcohol to a minor as a bartender, but he was never charged? Every time the case was dropped because they didn't have enough evidence. Well, a state attorney might look at those 3 arrests and say, you know what? Where there's smoke, there's fire, and I'm not giving you PTI because I'm not taking a chance. I don't like it. I don't like it, and I'm not doing it. And they won't do it. And there's nothing you can do to stop that from happening. So to piggyback on Michael and not belabor the point, there is a slew of reasons, but at the end of the day, PTI is offered by the state, and the state is like your dad or your mom. Sometimes they're going to put you in timeout, and sometimes there's not. There's nothing you can do about it if you don't like it.
Question number 3. When on the diversion program as a juvenile, when you finish your assignments early and turn them in, will you be drug tested? I was just wondering this for my friend because we both finished our assignments early and we are afraid to turn them in because we are not sure if we are going to be drug tested.
I am not that familiar with juvie cases, so
it doesn't matter, juvie or adult, principle's the same.
I don't know why he would be drug tested.
Anybody who's out on bond or who's in any diversionary program is subject to random urinalysis. Period.
Right. You're subject to it.
I don't doesn't mean it's going to happen, but it can happen. So the answer to the question is really simple. If you treasure your liberty and your lack of criminal history, and you're in diversion because you want to earn a dismissal, then comport your behavior accordingly. Right. If you are using illegal controlled substances while you're in diversion, you're an idiot. Yeah. Okay? I don't know how else to say that.
That's the short answer. Right, because Michael is right. You are subject to it. They can do it anytime they want. The reason it confused me is, why is he so worried that he's going to get drug tested? But I guess, Michael, you hit the nail on the head.
He's worried because he's using and he's not thinking about the potential consequences of his action.
And in fairness, if you think you have a drug habit and you are so severely addicted that you're terrified that you're going to test positive, you need to tell your lawyer up front, because this can be resolved with the court prior to you getting caught.
Well, and on this case, remember, it was diversion, so it's a little bit different because they're dealing with the state. But either way, the principle is correct. And I will add one thing to it. It depends on what you're using, right? Because if you're using marijuana and you have a medical marijuana card, you may, not definitely will, but you may have an out. But if it's cocaine or if it's ketamine or if it's MDMA, if it's substances that have no legitimate medical value, then it's obviously recreational drug use. And really, again, make up your mind what's more important to you. If you would rather be high, maybe consider moving to a place like, Seattle, where you can party like a rock star and not have to worry about it. But if you want to be here in Florida, you're going to have to be a little more careful about that. Let's hop on to the next one. Will I be able to live with my friend, which both of us are on probation? I am about to be released from prison after 21 years. My friend and I want to get an apartment together.
Okay. So again, that's not a bad question because it's a little complicated. The short answer is no, because you can be with people that are on probation. The answer becomes, what are they on probation for? What are you on probation for? Is anybody committing a felony at the time? Because you can't do any of those things. You can't have, for example, a firearm in the home, even if somebody says, well, it's not me, it's my roommates. Well, if your roommate doesn't have it locked up in a safe, you could get in trouble for that. So the short answer is no. Technically, you can live with somebody who's on probation, Once, like the last question, you're risking having your probation violated.
So I have a little bit of a different take on this. There are standard conditions of probation that every single probationer are obligated to live up to. Regardless of who you are, regardless of what you're on probation for, they are standard conditions. They're standard for a reason. They're standard because they apply to everybody across the board in every single case. On top of that, in any individual case, a judge is perfectly entitled to order what are called special conditions. And those would be tailored to that particular individual under those particular circumstances and that particular case. When you have an issue that's not contemplated by the rules, or that's not addressed by the court, or that you are not instructed by, you have a conflict. And how do you resolve conflicts? Well, the path of least resistance, and what most people think is, just reach out to your probation officer and ask. And if your PO says yes, it's a go. And if your PO says no, it's not. But there's a problem with that. And the problem with that is that your PO is free to do what he or she wants in that moment, as long as he or she is your PO. But as Ed and I know, oftentimes, just like judges and prosecutors and defense attorneys, probation officers get rotated or change or transfer or retire or get into car accidents or whatever. And your next PO may not honor what your prior PO did. So here's the general rule of thumb. And this is what I tell everybody under these circumstances. First off, I try to deal with these things before probation starts.
Correct.
I like to deal with them. I ask the client, whenever there's going to be a probation situation, is there anything we need to address now with the judge that'll save us a problem later? Because I don't want to have to charge him to file motions when we can resolve them right there in the moment. But still, things happen and you don't always anticipate everything. So the advice that I give is this. While you are on probation, your probation officer is the boss of you. However, the judge is the boss of your probation officer. So don't ever get into it with your PO. Don't argue with your PO. Don't fight with your PO. Have your lawyer file a motion with whatever question or issue you have. Get a court order, whether it's good or bad for you, and then live with it. If it's good for you, then your PO is going to have to live with it. If it's not good for you, well, then you know the answer to the question. So in this type of case, there is no standard condition that says two probationers cannot live together. However, there is a standard condition that says while on probation, you're not allowed to associate with anyone involved in any criminal conduct. I don't know that you can necessarily say that being on probation is criminal conduct, but you know what? Why take the chance?
Why take a chance?
Go to the judge. Ask the question.
And very wise words that Michael said. It really want to make sure it does not go unnoticed. Michael and I don't fight with your probation officers. So don't you do it. We don't argue with them. When I call them up sometimes, I say, listen, my client wants to travel or whatever. And they say, no, I don't want to agree to that. I say, okay, no problem. I understand completely. Do you mind? I'm going to put this on calendar. I'm going to see what the court says. Do you want to be present? What do you want me to tell the court your position? And I put it in the motion. Probation officer objects to this motion.
Absolutely.
No hard feelings, no fighting, and then let the judge decide.
It's real simple. And again, if you know these things before the fact, then you can address them at the time of sentencing and save yourself some money later. Because otherwise, we're going to have to charge you to prepare, file, calendar, notice, and litigate a motion where that may not be necessary. Let's hop on to the next one. Where are we? Number 5, I think. Can the cops legally search a parked car that does not belong to me? The cops walked up on us as I was out of the vehicle cleaning up the yard, and my friend was in the truck, which he was asleep. We did not have the keys to the truck. The truck was parked, and it was not our truck. Did they have a right to search the truck? I told them the truck didn't belong to us, and they could not search the truck, but they did anyways.
Okay. All right. So let me first address something. The first thing I want to address is the person asking this question can't even ask it. You don't have what's called standing to say no. It's not your truck. So you can't say no. You can't give permission unless you were actually sitting in it. You can't. You have no standing. So even if it's an illegal search, this individual can't do anything about it. The person who owns it is the one who could do something about it. So that leads me to my second question, or the second part of the question. Can they legally do it? It all depends on the circumstances and the reasons they did it. But at the end of the day, the person asking the question couldn't stop him from doing it, whether it was legal or illegal. And I don't know, because he's not giving me at least enough information to tell you whether it was an illegal search or not.
My first impression is, if there's somebody sleeping inside of a vehicle, 999 out of 1,000 times, an officer is going to be justified in doing what's called a welfare check.
For sure.
Make sure that person is alive, they're not overdosing on drugs, or suffering a heart attack, or whatever, or drunk behind the wheel of a car, which is illegal even if the car is parked in the state of Florida. So that would be the first thing I would point out.
Could they search the rest of the car? Could they go in the trunk? I don't know.
Well, who knows what they saw? Again, he doesn't give us the facts. So
that's what I'm saying.
It leads to my second point, which is this. And this is, one of those canned answers that I have to give a lot of times, because it's the nature of this type of a question. So the answer is, can they? Of course they can. They did. So that's not the right question. The question that you should be asking is, if you got arrested or if you suffered damages, what do I do next? What do I do now? That's the question. Because what a cop does in the moment is all fine and dandy unless and until a judge decides that it wasn't appropriate. And the only way that happens is if a legally sufficient motion is prepared, filed, calendared, noticed, and then litigated, or if the state attorney happens to agree. But at the end of the day, asking a question like this online is really a waste of everybody's time, because we need to know, what we do know for certain is that in every single criminal case, there's at least three sides to any given story. There's the probable cause statement of the officers. This is their version of events as to why they chose to make an arrest. Then there's the defendant's story, which is usually something very different than what law enforcement says in their version. And the third is what a judge or a jury ultimately believes, which is usually some combination of both, but we don't know what. Either way, in order for Ed or I or any other lawyer to responsibly opine to a question, especially one regarding Fourth Amendment analysis, which absolutely involves a deep dive into the very unique facts and circumstances of every individual case, in order for us to give you a competent opinion on that, we need to know more than just your one-sided proffer. We need to read those police reports. We need to know what is it that the cop said, because I guarantee you that their version of events is a little bit different than this individual's.
And also, very importantly, doesn't matter. You don't need to know, because you don't have a right to fight it anyway. So, for example, if they found a duffel bag in there with your name written all over it, and it had 15 kilos of cocaine in it, you have certain defenses, but one of them was not the illegal search, because you don't have standing to argue that illegal search in the car.
Here's another one for you.
Don't leave your drugs or any illegal substances in somebody else's car.
Can I ask for money online to strangers without telling the truth of what I am going to use it for? I was wondering if I can make an account on, for example, Tinder, but not using pictures of me instead of someone else, because I want to be safe, but I would use the account to ask for money, but I would not lie about what I'm using the money for.
What? Okay. All right. First, this is so convoluted and complicated that I would just suggest you don't do it. Secondly, this really smells, from the very beginning, really smells of fraud. So, again, we need a little more facts. Depends on what money you're getting, why you're using it. I mean, if you're not going to use your photo, but you're going to be honest about everything else, fine. But if you're using, like if I'm using Michael Haber's photo and I'm saying, I don't know, that I
have cancer, please donate money to me.
That's fraud.
Right. At the end of the line, I don't care what the reason is. If you are impersonating another individual and soliciting money under the guise that you are someone other than who you are, then regardless of the righteousness of your cause, the odds are you are committing a fraud, and not only a fraud, but a federal fraud.
But
because if people are donating money online, that's interstate commerce, and that implicates the federal government.
But let me be clear, right? If you have an organization that you want to start raising money to help I don't know, stray dogs. Okay. You want to have a dog farm and you want to start having stray dogs and you want people to help donate for your farm and you hire an actor to be part of your website. Well, that's different. You're not saying that you're that person or that person is the reason you're looking for the money, but it smacks of you.
Right, but even then you have to say, paid political advertisement, or I'm not a doctor, this is,
Well,
an actor. You have to be, look, if you're gonna request, if you're gonna go online and create a GoFundMe or what have you, it's got to be legit. If it's not legit, it's fraud, period.
Unless, of course, well, I was going to say something, but I'm not. There are certain organizations that we know very well have been over the media who got billions of dollars and used.
Let's try number 7. Why would a passenger be completely erased from a traffic stop discovery as if he were never there? If there were 3 passengers in the car and the car was searched and all 3 were detained, but only one was arrested, how is it possible that one of the 3 is never mentioned in any police report or in any of the discovery?
That's why you hire a lawyer. No, cops should not do that. Cops are humans and they make mistakes. Some of them do it nefariously. Most of them don't. An officer should put every person that was on the scene that had any relevance to the case. And I would argue that a passenger in a vehicle has relevance. However, maybe the officer didn't think that it was relevant because the person had nothing to do. Let's say it's a DUI stop. Michael's driving and me and someone else are in the vehicle. They stop Michael for a DUI. We get out of the vehicle. We've done nothing wrong. They're going to let us go. And the cop thinks, well, I don't need to put who else was in the car. It's possible that's what he did. However, that's why you hire a lawyer like Michael and I to take a depo or to talk to the state attorney, talk to your, obviously, if the person who got the DUI hires me, he's going to tell me, hey, my friends were in the car. And that's something that I'm going to address with the cop. But no, he should have put it in there.
I don't really have anything to add like that to that. That's pretty much what I said. My answer was, this sounds like sloppy police work, and that's what defense attorneys are for. We don't know the why of it. It may be that person was irrelevant, but the truth is, as Ed said, the police and the state attorney should list everybody. Not everybody is going to be a relevant witness to the case, but they should disclose everything that they learned during the course of their investigation, whatever led up to the arrest. When will my son's judge acknowledge the notice of counsel substitution? It has been 4 months since this notice was filed. The attorney did all of the necessary paperwork in order to get the public defender removed and substitute in as his new lawyer. We are not sure why it has taken this judge 4 months to say yes or no about substitution. The judge is a new judge. What should we do?
Okay. Once again, this is a question that I think is missing a lot. And I think it's what Michael said. It has a lot to do with them not understanding the process. When they say the judge hasn't put the new lawyer, does that mean it is not showing up on the clerk's website? If it shows that the public defender is still the attorney of record on the clerk's website, doesn't mean anything. They make mistakes. Sometimes they don't put it in. Things happen. If the judge hasn't ratified the order, and that's what you want. You file a motion with an order, and you're asking the court to ratify it, to say, yes, I'm okay with this. If the judge hasn't done it in 4 months, then the question is, did the lawyer put it on calendar? Judges don't go through every case on their docket to look and see what everybody filed every single day. It's up to the lawyer to let the judge know, hey, judge, I filed this. Can we have a hearing? Or can you just rule in chambers or do something? So it's possible that the lawyer hasn't let the judge know that it's there. So again, not enough information to tell you exactly why he hasn't done it. I will tell you that he will get around to ruling on it if he hasn't, and he's going to say yay or nay.
Well, and I'm just going to add to that to say this. It's another example of a misplaced question. You're asking random lawyers on the internet to explain the why of something to you that we know nothing about. This is a fact-specific, case-specific, defendant-specific question. You know who has the answer to this question? The judge and the lawyer.
And your lawyer.
Why are you not on the phone with your son's lawyer saying, dude, what is going on? Get us in front of the judge tomorrow.
Right.
Well, I don't get this because, again, it's just so, to me, it's so common sense when I read it. it's very easy for a lawyer to substitute. Believe me, the public defender is not fighting to stay on any case.
Nope.
In the history of public defenders, that has never happened.
As a matter of fact, I have filed substitutions. The case has come up on calendar for something else. I didn't put it on for anything. I don't usually do it because when it comes up for the next setting, that's when it gets addressed. And it's not necessary because I'm working on it. I'll call the public defender and tell them,
right. And a lot of times it's unnecessary anyhow, because the Sixth Amendment is pretty clear that any criminally accused has the right to counsel of his or her own choosing. You don't have the right to a public defender of your own choosing, but if you want to hire private counsel and have them substitute in, very rarely can a judge interfere with that. The only circumstance where I've ever seen a judge give anyone a hard time is if there's a viable sense in the judge's mind that it's a delay tactic because the case is old, it's set for trial, and they're just jerking off the court and trying to put in a new lawyer to cause delay where there shouldn't be. But shy of that, no judge in the world is no judge in the United States is getting in the way of a defendant's Sixth Amendment right to have the lawyer of their choosing.
And to be crystal clear, I don't know of one judge that would not give an enormous amount of deference to the defendant, even when they think you're bullshitting and you're just hiring another lawyer because you're trying to drag this out.
No, it would have to be bad. There would have to be a history. There would have to be something there.
They'd have to have warned you for like 2 or 3 lawyers in a row.
So for this particular question, this particular asker, either you hired an incompetent lawyer or you don't know what's going on with the case. It's really that simple. No,
or hire somebody else.
Right. Next question. Is it illegal to send pizza to someone's house and request to pay in person? I want to send a pizza to my ex without him knowing, and I want him to pay for it.
I don't even understand. I don't even understand why you would do this. Clearly, there's something going on there. Is it illegal? I mean, I don't know. I don't think it would be illegal. I don't know why your ex would pay for it.
Yeah, I think it is illegal to order goods with no intent to pay for them. I think it's illegal I think it is a fraud. And if it's provable, I think this person could certainly be charged, and they could certainly be slapped with a restraining order or an injunction. This opens up a lot of doors. I mean, I can tell you that, look, I try to have a pretty good bedside manner, but every now and then I'm a little bit snarky. And so this was my answer, and this one was,
and I've never seen anything like this.
Yeah,
ever.
No, my answer to this was, WTF is wrong with you? Grow up, move on with your own life, and leave your ex alone.
Yeah.
I mean, I could have been more eloquent in the way I stated that, but the truth is, this is so juvenile and so foolish that
this could be, and you're right, it probably would be considered what they call in Florida, if they still call it this. I haven't seen one since I was in county court 20 years ago. Defrauding an innkeeper. It's like
could be
skipping out on the bill. So you ordered food and you didn't, but they'd have to prove that you had no
dine and dash.
I mean, you would have to, when the cops come, you'd have to say, "Oh yeah, no, I knew my ex wasn't going to pay for it. I just did it to
how about when they print out this question on Avo and use that against you?
Correct.
So, there you go.
Next one.
All right. Who decides whether or not to incorporate an ankle monitor along with probation? It is written within the plea bargain when accepting the plea. Is it written within the plea bargain when accepting the plea, or can a plea be accepted without mention of an ankle monitor and then it be added on at a later date? Does the probation officer have the authority over the judge to apply it in addition to the defendant's signed plea if the probation officer wants to?
No.
We've already answered this question.
You colloquied, the defendant is colloquied, and they are told exactly what their sentence is going to be. And if that sentence includes an ankle monitor, then the judge will tell you it's an ankle monitor. Now, is it possible the judge forgot to mention it to you and it was in a written plea agreement? If that's the case, again, this is why it's hard to answer these in a vacuum. If it was in a written plea agreement and you supposedly read the plea agreement and you signed that plea agreement, and when the judge asked you, said, "Did you read everything in here? Are you aware of the sentence?" And you said yes, then it probably will stick. But if not, then no, the probation officer can't just spring it on you because they want.
We've already hit this. POs have no authority. A PO's job is twofold. There's only two things a PO does. They supervise and they violate. That's it. They have no authority to impose conditions. Now, they can file an affidavit and then you can wind up in a VOP and the judge can make a more harsher sentence if they find you in willful and substantial violation, but that's a separate question.
VOP being a violation of probation.
Should I get a lawyer or a public defender? I was detained at Walmart and given a court summons for petty theft. I was getting food and personal items for my family. Nothing frivolous. My food stamp card had $500 on it the day before. Apparently, it was there a while without me realizing. I had planned my grocery trip and then found out that my food stamp money was taken away for non-use. I have an 8-year-old son with autism and behavior disorder and a 16-year-old son in high school. I am scared of what the possible outcome may be. Is going to jail or a huge fine possible? I am unsure if I should ask for legal help. Please let me know. Should I get a lawyer or a public defender?
Okay, I stopped listening after you said, should I get a lawyer or public defender? Only because none of that matters. Here's the answer and I'm going to put it in a very simple analogy, and then I want to explain. That would be like asking me, should I get a Ferrari or should I get a Corvette? Well, they're both good cars. Just one is made with more detail, and the people who make it have more time to put effort and attention to the vehicle because they charge so much more that they can pay attention to that Ferrari more intently. Whereas Chevy makes a lot of Corvettes, and so they got to pump them out, but they might make a great Corvette. So here's my question. Here's the real answer. There are plenty of amazing, great public defenders. Plenty of them. Okay. Obviously, like everything else in life, some are better than others. But the one thing that every public defender has in common is an enormous amount of cases. Whereas a private lawyer, who could be just as good as the public defender, is going to have fewer cases so they can invest more time and effort and energy into the case. That's the only difference. If you get now, you may, and the other thing is you don't get to choose which public defender you get. So, you may want the guy who's the greatest or the female who's the greatest public defender in that office, but unfortunately, you don't get to choose which public defender you get.
So I agree with everything you said, but I think you completely missed the mark on this question.
Okay.
The question is, should I get a lawyer or a public defender? And the answer is much simpler than what you put forth. The answer is you don't have a choice. You only get a public defender if you are indigent and cannot afford a lawyer.
You're right.
If you can afford to hire a lawyer, you cannot get a public defender. So this is not a question to ask. This is a financial issue that the judge will ask. You either are indigent and therefore entitled to a public defender, or you are not indigent and you're stuck footing your own legal bill.
However, the caveat, and this is what I was thinking of, the caveat obviously is some defendants are entitled to a public defender, but they have family members who want to hire someone.
Right.
And
that's true too. So all the things, I agree with everything you said.
And I agree with
I just want to make sure that the answer is there so that people do understand that.
Correct.
You're always free. Again, somebody could set up a GoFundMe page for you. It happens all the time. People get accused of crimes. A GoFundMe page goes up, and all of a sudden there's tens or even hundreds of thousands of dollars in there for somebody's defense.
And I want to use
in fact, I think Kyle Rittenhouse had a GoFundMe page that paid for all of his legal defense when he was accused in Wisconsin or wherever it was.
I just want to use this question, Michael, as an example of something else you and I talk about a lot. Notice how Michael and I are both very experienced. Michael and I both agree with each other's answers. Okay. Michael and I have talked about this many times. A good lawyer will understand the value of running his ideas on a case by another lawyer. Because it doesn't mean you're stupid. Doesn't mean the other lawyer is smarter or better. It just means that he may have seen something from an angle that maybe you missed.
Different prisms.
Right. So it's if you have a lawyer who says I don't talk to anybody else. To me, that's a red flag. I would rather have a lawyer who says, you know what? I got a colleague I'm going to call. I'm going to run this by them. Because true professionals know that, okay? Major League Baseball players, if I've never faced a pitcher before, or even if I have, I'll talk to another guy who's a good hitter who might give me an insight to how to face this guy. So you always want to talk to other people. And this was a prime example. I missed that part of the question. He's right. First, you have to qualify before you can get the PD.
Will Illinois come extradite someone from Florida? My husband is incarcerated in the Ukalasa Department of Corrections. He has a misdemeanor. The misdemeanor is driving on a suspended license. He has a felony for unlawful use of a vehicle. Will they come pick him up, or is there a chance that they may decide not to extradite him?
All right. So the last part of that question is the real question. Is there a chance? Because will they is not the right answer question. The question is, can they? That's the legal question. Under most circumstances where they have an open case, pending case, blah, 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 yeah, they can. Question is, will they? It all depends. It all depends on how badly they want to prosecute your husband. It was her husband.
How much effort and resources they're willing to expend to do it.
Right.
So every case is unique. And look, warrants are there. I mean, I had one guy who I represented who had a fugitive misdemeanor out of state warrant. He was picked up in Florida 14 different times, spent close to 30 days in custody on each of those 14 different arrests. And the warrant was never rescinded or recalled, and they never extradited him. But after 30 days or so, he got released each and every time because the local municipality said, we're not going to hold this guy indefinitely for a state that's not coming to get him.
Right.
But at the end of the day, when there's a warrant with your name on it, you have to deal with it because otherwise it's a cancer. And just like cancer, if you don't deal with it, at some point it's going to deal with you.
And you know what? For a fact, it usually raises its head at the most inopportune moment. When you're about to go to your daughter's wedding, when you're about to take a vacation with your family, deal with it as soon as you know, because trust me, it's Murphy's Law. It always pops up when you least would like it to happen.
Does a hospital have the right to deny a visit to a family member due to being on an offender's list? Someone I know is on an offender's list and was denied the right to see his father in the hospital due to being on the offender list. The hospital is not a private hospital. We filed a complaint. They said it's their policy, but they refused to show us the policy. They only screen against offenders and crimes committed in the hospital. I feel that this is discrimination because they may allow in other felons, but not offenders.
Do you know what they mean by what do they mean by offenders? Do they mean like an injunction?
I don't know, but here's the problem that I have with this question. Okay. My problem with it is whenever I read, I don't feel that this is appropriate. That's where I lose interest because it really has no bearing on what you feel or what you think. And by the way, by this person's own proffer, it's not even their problem. It's somebody else that they're venting about. So you know what? Suck it up, Buttercup.
And
you don't have any right to go into a hospital. The hospital has every right to deny you access. And if you feel that you're unlawfully denied and you feel that you're being discriminated against, go consult a civil lawyer and see if somebody's willing to sign their name on a lawsuit. If they are, you're probably right. And if they're not, you're probably wrong.
Okay, so along those lines, it's probably a question that's better asked on Twitter. They probably have a lot more fun asking this on Twitter.
Exactly.
If I just do want to make this clear, if what they mean by the offenders list, which I don't know what the hell that is, and if it was from the state of Florida, I definitely have no clue what the hell they're talking about. That doesn't exist in the law in Florida. But if they mean an injunction where there's a stay away order from, let's say he had a stay away order from,
what I think they mean,
they're not allowed to do that.
Yeah, what I think they mean is they mean offenders of the hospital system, people who are like blacklisted from the hospital itself.
Well, for like not paying bills? Oh, yeah.
Whatever. I don't know. Whatever the reason.
Yeah, that's a civil matter. And yeah, go ask that question on Twitter or get a civil lawyer.
Exactly. All right. I'm on probation for driving on a suspended license. I violated with a new charge for the same thing 4 months into my probation. I got a new charge for driving on a suspended license 4 months into my probation. I was coming home from doing community service hours. I got pulled over. They kept me in jail for 10 days, and then I got a bond before my VOP. I go to court tomorrow, and they said my VOP is there. Now I have a warrant. How long am I going to be in jail?
Okay, so as those of you that were watching saw me put my head in my hands because I just cannot cease to understand how do people do this. You just got arrested for a suspended driver's license. That means you know your license is suspended and you drove anyway. I don't care what the reason is. I love it when they say, well, my kid got hurt and I was rushing him to the hospital. Call 911.
Right. Well, this guy was doing community service hours.
He's doing it for his community service hours. Nice. How long are you going to spend in jail? That all depends on how pissed off the judge is. Okay? Because this is an issue for the judge, and this is another topic that I want to get across very clearly. While we go to court, and when you violate your probation, the court will ask the prosecution, What is their opinion on what should be the sentence for violating if you're found to violate, and the probation officer as well. It is irrelevant. When you're on probation, you are at the sole mercy and jurisdiction of that judge. So the state could say, let him go. And the judge could say, thank you very much. Go screw yourself. I'm putting him in prison. Or the state could say, we want to go in prison. And the judge could say, you know what? Not a bad guy. I'm going to dismiss the violation. So you really want to know? You better find out what that judge is and are they pissed off at you? Because that's the only one that matters.
So I have a slight take on this, and that is, I agree with you, okay? Probation is a gift, although it's a gift given by an Indian giver, okay? It's basically just enough rope for you to hang yourself. You have very limited rights in a probation violation hearing. They're nothing like a substantive criminal trial. The deck is stacked against you. Doesn't mean you can't win PVHs, because we do beat PVHs, sometimes very creatively and sometimes on the law. But either way, it's a battle that you really shouldn't want to fight.
Yep.
And when you go in front of a judge on a PVH and you have a new substantive arrest, and it's for the same exact thing that you're on probation for, basically what you're doing is, pardon my language, but you're taking a crap on the court.
You're doing this to the judge.
Yeah. You're basically saying to the judge, here's what I think about you and your rules and your laws. And you can expect to be treated as such. So, think about that before you, go ahead and act. All right, here's a little type of a different one. Can I write a witness statement only using my first name with no other information? A friend of mine is charged with a crime of bullets by convicted felon. But the bullets belong to a drug dealer who tried loading a gun during a drug deal, who got pissed off with her husband, who the drug deal was with, when his wife hit him with a golf club in the hand. And he dropped the bullet that he was trying to engage into the gun and several other bullets. And now she's being faced with the bullets charge. He wants to give his statement to help her, but he doesn't want to get into any trouble. Can he and I both write statements using only our first name?
My first question is, let me see if I got this fact scenario correct. So there's a person who was trying to load his gun during a drug deal. And there's a convicted felon who was there to hit his hand with a golf club. Why was a convicted felon at a drug deal?
See, here's one where I don't even get into the weeds of it. Because on its face, the answer is no. I mean, you can do what you want. You can write what you want. You can submit what you want. But number one, witness statements or affidavits are inadmissible hearsay.
Correct.
Number two, prosecutors and defense attorneys cannot rely on an untested, uncorroborated statement from somebody who's not fully identified. If you're a witness, you're a witness. You've got to be tendered, you've got to be disclosed, and you've got to be subject to cross-examination. Can't do it half-assed.
That
doesn't work that way.
That affidavit is as good as Sharman if you don't put your last name.
No, Sharman's actually better.
If you put your last name on it, it's not much better than Sharman.
We kind of touched on this already, but I'm going to throw it out anyhow.
Yeah.
Sorry,
before we move on, I just love how they just glossed over that they were at a drug deal when this happened. So why were you there?
My PO sent my brother to prison. She did not like him. I ended up getting the same PO as my brother. Now she sent me to prison. How do we get new POs? I think she does stuff out of spite because she never liked me or my brother.
Okay. Why do you ask these questions that just, what am I supposed to do with that, Michael?
Exactly. I don't know.
There's no facts. I don't know. I have no idea.
It actually is a really easily answerable question. And that is, look, you don't get to choose your PO and you don't get to decide how your PO acts. The truth is, if your PO is unreasonable, you go to the judge. That's what you do. And if you really have a complaint against your PO, you talk to your lawyer before you do this. But just like you can do with a police officer that you have a problem with, you can go file an internal grievance. DOC has a mechanism for complainants, including probationers, to file complaints. The truth is, they don't want bad POs. There are bad ones out there, and they don't want them. They don't want the reputation. They don't want the hassle. They don't want the lawsuits. They don't want the bad press. Right. Just like police departments don't want bad cops. Doesn't mean they don't exist, but if they come to light, they want to get rid of them. The quicker they get rid of them, the better the department looks. Same thing for a PO. That said, I find it hard to believe that this PO had a personal grudge against these two brothers. And by the way, POs cannot send anybody to prison. Only judges can.
Right, only judges. They
So,
violate.
right. The PO can file an allegation alleging a probation violation, but then that individual is entitled to due process and a hearing, and the judge has to make a determination. And if the judge finds willful and substantial violation, then sentencing is at the discretion of the court. Although the PO can make a recommendation, the judge can accept it, but is not obligated to. And like Ed said on the previous question, judge could reinstate probation if he or she wants, or max the person out in jail or prison. Up to the judge.
And the fact that both these brothers went to prison, meaning they were before a judge, kind of makes me believe that the PO is not necessarily have it out for them. But who knows? Maybe.
Let's hustle and try and get through these last three so we can hit 20 even.
Let's see. Okay, quick.
Okay. Can you go to jail from your tint too dark? Got followed about mile from police, and he pulled me over for tint after he tested. I asked him give me my ticket so I can go. He asked for my license and the rest of paperwork I gave him that he said he ran my name and he said my license was suspended. I gave him a hard time because I knew I had a license, so he detained me. He ran a canine around the car. It alerted on what he said was crack. After that, police walked up and said, dude, license is good. Was charged with possession charge, which he states front floorboard and back seat. Is any of that paper cause, I think he means probable cause. Any you lawyers can beat that, I want to hire.
So let's take the most. Okay, you want to start because I mean the only thing that I see here that is even could possibly be an issue is that he can only run a drug dog around your car. So first of all, let me start with this. No, you didn't go to prison because your window tints were too dark.
Correct. That's issue number one.
That's issue one.
That's the first false premise.
Right. That's why you were stopped. No, nobody goes to prison for tints being too dark. Now, the fact that he thought your license was suspended, well, that's an issue that maybe we would have to look into because he can only run a drug dog around your car for as long as it would take to run a ticket unless he has other probable cause. So in this case, if your license was suspended and he believed because he ran it in the system and it was a good faith effort on his part that he really thought your license was suspended, that now becomes an arrestable offense and he could have taken his sweet ass time to run a drug dog. If he made a mistake, then I think a judge would say, well, the next question I have is
how long?
Right. How long did he take to run that drug dog? So can somebody beat it? Maybe, but we need a lot more facts. And to be honest with you, it doesn't look good.
Another one of those Fourth Amendment questions, very case specific, and we need to know the other side of the story. But again, cops don't need a reason or a warrant or probable cause or even a spidey sense to run a canine around your car. They just need to do it within the time that it takes to conduct the traffic stop and conclude the business of the traffic stop.
And
so if they detain you for an unreasonable amount of time, let's say he keeps you on the side of the road for 2 hours waiting for a canine to show up, that's another story. But if he's a canine officer and he had the dog in his car, you're done.
And just to be crystal clear, two things. There's no case law that I know of, unless something has come out recently, that says exactly how long that period of time is.
No, it's reasonable. It's got to be a reasonable amount of time.
Wait. Number two, it's not what you believe is reasonable. It's what a reasonable person would believe is reasonable.
Right. And the other thing is there are other issues. Whose car is it? Where were the drugs found? You know, is there any explanation that you might be able to deny knowledge of the fact that drugs were in the car? Maybe you were driving someone else's car. Again, this is why we need to know a lot more before we can give you a case-specific answer. All right, here's one for you, Ed. No. Can I press legal charges on my lawyer? My lawyer got me a deal for felony charges. I asked a couple of times, will the deal include me having to register as a felon? He said no, but that did not end up being the case. Can I press legal charges on my lawyer?
Well, what do they mean by legal charges? You can't have him arrested. You might be able to say, report him to the Florida bar if he did something that was actionable. But the short answer is going to be no, unless you can give me something more. I don't understand.
Yeah, you can pretty much only press charges against your lawyer if they commit a criminal act, like punch you in the face, steal your money, something like that. But otherwise, the recourse for you being wronged by your lawyer is what's called a Rule 3. It's an appeal for ineffective assistance of counsel. And that may get you out of your plea. But then again, you always have to be careful what you ask for because you might just get it.
Yep.
All right, last one because we're almost at the hour mark and we will hit 20, which is a pretty good number.
That's not bad.
I got pulled over by cops after getting a massage. I got pulled over last night in South Florida after getting a massage. The cops asked me to give them a sworn statement. They mentioned that they are targeting the massage parlor and that they want to shut it down. They took a recorded statement from me and let me go. Will I be in trouble?
Okay. Again, that's not the answer. Will you depends. Can you? Maybe. Chances are no, because they're trying to obviously get the quote, Michael, look at me, the massage parlor that you went to. They've obviously been told what is actually going on in there. And sooner or later, they might send it undercover. Usually, when it comes to these massage parlors, they need the Johns or the people that go get a massage to be able to do a good case. So,
unless they have video set up.
Right. So will you?
Google Robert Kraft.
Yeah, exactly. So will you? I can't tell you if you will or you won't. Can you? Of course. Anytime you talk to a cop, it's a confession. Listen to me carefully. Michael has said it 100 times. Anytime your lips are moving and there's an officer in uniform, it's a confession. Even if you're saying, oh, I didn't do it, it's a confession. All right. And here's the bad news. I've said this 1,000 times because a lot of people don't know this. If you talk to a cop and you say, I didn't do it because it was that guy walking down the street and I have nothing to do with this, the jury will never hear that because the state attorney keeps that out as self-serving hearsay. So there is absolutely zero motivation to talk to a cop without a lawyer present. Okay.
The only thing I can add to that is the modified acronym that hashtag HaberPA puts out every day on our PSAs, and we repeat with great regularity, and that is hashtag UpX2. Invoke the 5th and the 6th. Shut up and lawyer up.
Right.
There's no reason for you to talk to the cops. You can't be compelled to talk to the cops. Once you do talk to the cops, you can't unsay anything that you said. You're now a witness. So if they go against the massage parlor, guess who's going to be listed by the state and called as a witness? You. Guess whose name is going to be in the newspaper? You. Now, if the cops pulled you over and said, well, you just left the massage parlor, you can say, okay, and your point?
I want to.
Well, we need to know X, Y, and Z. I'm sorry, I just got a massage. I don't know what else you're talking about.
I wouldn't even say that much. I would say, great. You know what, officer? I'd love to help you. Let me get my lawyer on scene, or we'll arrange a meeting, and we'll do it with my lawyer. And this is why. If Michael is being asked whether he was at the massage parlor, no matter what Michael says, it's a confession or self-serving hearsay. I could come in and say, okay, let me tell you what happened with Michael. So Michael told me that he did this and this, and then the chick started grabbing his privates, and before he could stop.
So what Ed is basically saying to you is anything that you can say, your lawyer can say both safer and smarter.
And this is why it's safe. Because me telling that officer is hearsay. And there's no exception to that rule. So I could basically confess to the crime to this cop, and he can't.
As a lawyer.
He can't use it.
But again, once this guy opened up his yapper, he now inserted himself and created a potential problem. Now, the truth is, maybe they did arrest him no matter what. Maybe they would have done it. Maybe if he didn't cooperate, it would. But there'd be no evidence. Unless, of course, the massage person came in and testified that that's what happened, or in fact, they had video footage. Again, Google Robert Kraft. All right, we're a few minutes over. So, I mean, look, we got through 20 questions. And again, these are real questions that were asked by real people on Avo. They were not altered or modified in any way. There's no way to know who these people are by name. They don't give their names. Sometimes they give a first name. But there is an email trail that Avo has, because in order to ask the question, you have to sign up and submit it. So, technically a prosecutor could subpoena that information. So remember, it's like WebMD. Is it a good source for some information? Yeah. But is it a place to get definitive answers? Probably not, especially in case specific, like Fourth Amendment type analyses that we've had a couple of that we discussed today. Those you really need to sit down with a lawyer, and the lawyer needs to vet both sides, all angles. because that's the way the court is going to look at it. They're not just going to listen to the client and pretend the state and the cops have absolutely no version of events.
And it's not good enough for you to say, well, I read the report. What the cop is saying is a lie. Okay, but your lawyer still needs to read it because a judge may not think the cop is a liar. So you can't really answer these questions as a lawyer.
And by the way, the cop may not be lying.
Right.
So, there's always that to consider too. All right. With that in mind, let me thank everybody and apologize for our late start and going over just a little bit. Our producers will upload this stuff to YouTube and the various other social media channels as soon as the show is over. And then, of course, I will do the same. So if you watched live, we thank you very much. We appreciate your time on a Monday afternoon. And if you are not watching live and you are watching after the fact, then we appreciate you just as much, if not more, for taking time out of your life to see our show. I hope we gave you some good pro tips. I hope we gave you some good information, and that we're leaving you with some more solid footing. Please feel free to ask us anything you'd like directly. You can always reach out to me or Ed through any of our various channels of communication, and we're happy to talk to you. But remember, the advice that you get really is going to vary depending upon the amount of information that the lawyer has to assess it and be able to give you a complete picture. Otherwise, we'll be the first ones to tell you we need to know more. With that, thank you for watching episode number 72. I believe that we're going to have a show next week on the 14th. I'm not 100% sure. I think, Ed, you have a trial call.
I got to double check, but I may be in trial.
And I believe we have a guest set up on the 21st. But we'll be in touch and let you know for sure. Again, thank you all very much. It's our pleasure to be able to be here at your service. And we want to wish you all a fabulous week ahead. Take care. Thanks for joining me, Ed. It's always good to see you, buddy.
Take care, brother. Bye-bye.
And thank you guys at Miami Communities Newspapers for doing such a bang-up job as always. We appreciate you.
Bye-bye.